about NAR's new standard of practice 10-5 regarding hate speech. That will make up probably the bulk of the presentation. And then finally, I'm going to touch on the new guidance related to disciplining designated realtors and brokers. And after that, we'll have the Q&A session. So first, the peer-to-peer ethics info line. So the reason that this was created was that several brokers had been mentioning at conferences that it would actually be useful to have a separate hotline that realtors could call when they have a question about the code of ethics. Now, of course, we have the CAR legal hotline. That hotline is for a realtor to talk to an attorney when they have a legal question. But it was thought, what if someone just has a question about ethics and maybe they want to talk to another practitioner, another realtor volunteer about the subject? And that's kind of the idea behind the info line. So back in 2019, there was a budget objective asking the corporate legal department to take a look at whether it was feasible to create this info line and to determine how it would be implemented. And so at the professional standards committee level in 2019, there was a work group formed to figure out how the info line would be structured and whether it would be feasible. And the work group decided that it would be a good idea and that it would be feasible. And they prepared a report and recommendation for the fall 2019 meeting. The work group recommendation was passed, and we were planning to implement it in 2020. But of course, all of you know what happened in 2020. So we were a little bit distracted with a lot of things related to the pandemic. So we put the peer-to-peer ethics info line on the back burner for a little bit. But then starting in the first half of 2021, we had some time to move forward with implementation. And the peer-to-peer ethics info line was in fact created and launched in April. So here's a little bit about how the peer-to-peer ethics info line recruitment worked for the volunteers that are serving on the info line. The work group decided that the volunteers would be recruited from ombudsmen and from local association grievance and pro standards committees. And the info line of volunteers needed to be experienced in professional standards and have an in-depth knowledge of the code of ethics. So to be eligible to serve as an info line volunteer, the following criteria were instituted. So the volunteer needed to have either at least 3 calls as an ombudsman, at least 3 years serving on a local association grievance committee, or at least 3 cases serving on a hearing panel as a member of a local association pro standards committee. So any one of those 3 things will qualify someone to be an info line volunteer. There was an online application form created for anyone that is interested in applying to be a volunteer. And by the way, if you are still interested in being a volunteer, that application is still available on the CIR website. So you can become a volunteer if you didn't yet and are interested in doing that. So after you fill out the application, there is a little training to be an info line volunteer. Each volunteer is required to take a webinar training class, which we did a live version of earlier in the year, but there's a recording for anyone that wasn't able to take it live. And after the webinar, volunteers will need to complete and pass a written exam in order to become certified as a peer-to-peer ethics info line volunteer. The volunteers are required to take the training class and pass the exam to get recertified every 2 years. So we had the 2021 training, like I said, in March. For anyone that wants to be an info line volunteer, like I said, it's recorded, so you can sign up, fill out the application, and we'll send you the recording of the training to take. So what are the permitted topics for info line volunteers? Well, according to the work group, it was decided that the volunteers will provide oral responses only to info line callers, no email or written responses. Professional standards hearing panels are not bound by the advice that's given to info line volunteers. And the volunteers can only answer questions about the code of ethics. They're not allowed to answer questions about real estate law. So anything related to real estate law should be forwarded to the CAR legal hotline. About MLS rules or association bylaws. Infoline volunteers also have to refuse to answer questions from members who are currently parties in local association disciplinary cases. So the policies and procedures we set up for the info line is very similar to how the ombudsman hotline works. Callers initially contact a CAR staff member who does an intake process, or they can fill out an online intake form. Then the staff member will assign the caller to a particular info line volunteer, and that will be a volunteer located in a different market area from the caller. So Los Angeles County callers, for example, are assigned to a volunteer located in a different Staff members provide the intake form and the caller's contact information to the volunteer. And then the volunteer contacts the caller by phone to answer the caller's question. After the call, the volunteer has to complete a final report just to close the loop with CAR, summarizing the caller's question and the volunteer's answer, and then the volunteer returns that final report by email to the CAR staff. With that data that we get from both the intakes and from the final reports, we're going to be using that to focus our educational efforts concerning the code of ethics. So for example, if we notice that a large number of infoline callers are asking about a specific subject, then we can, for example, schedule a webinar on that subject. So that's kind of how the infoline is working. It launched on April 5th. During the first month, we got about 60 callers to the infoline, which is pretty good, maybe even more than we're getting actually for the ombudsman program. So the link here, and I will send to Jenny the PowerPoint presentation, and she can forward that on to everyone who registered for this training. But here's the link to the infoline, and if you go to that link, you can also find a link if you want to apply to be an infoline volunteer. So like I said, there's an online intake there, and then there's also a phone number you can call for the info. All right, so now I'm going to move on to our second subject, which is the new standard of practice 10-5. And this is the standard of practice that was passed by NAR back in November of last year related to hate speech. So first I'm going to talk about what was included in what NAR passed, and then I'm going to get into a lot more detail about frequently asked questions about this new standard of practice. So first, here's a summary of the changes. On November 13th of last year, the NAR Board of Directors voted to make some significant changes to the pro standards policies, and those changes went into effect immediately upon enactment by the board. And specifically, NAR voted to do three things. The first bullet point is the most important one because it created the new standard of practice 10-5. And what 10-5 says is realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So that is the new standard that is in the Code of Ethics. In addition to that, NAR revised a professional standards policy statement to expand the applicability of the Code of Ethics to all of a realtor's activities, not just real estate related activities and transactions involving realtors. So this policy statement needed to be changed solely because of the new standard of practice, because NAR intended it to apply not just to statements that a realtor makes in the course of their business as a realtor, but any statements that a realtor makes publicly, including on their personal social media accounts. And so this policy statement had to be changed to make it clear that the Code of Ethics now applies to all of a realtor's activities. And then finally, NAR revised the definition of a public trust violation. Now, public trust violations are those violations that NAR considers some of the most egregious and important. And according to NAR, a public trust violation, once the hearing has concluded, has to be reported to the state licensing authorities or the proper governmental authorities. So the definition of a public trust violation was expanded so that now, pursuant to NAR policy, public trust violations include all forms of discrimination and all forms of fraud. So previously, a public trust violation was only deliberate discrimination. NAR removed the word deliberate there. So any discrimination that's a violation of the Code of Ethics is now a public trust violation. Also, formerly, it used to be fraud resulting in substantial economic harm was a public trust violation. NAR removed the word substantial economic harm, so now all fraud violations are considered to be public trust violations. So those are the three changes. The one we're going to be talking about the most, of course, is the first one, the new standard of practice. So now we've got a kind of a list of frequently asked questions that I'm going to address about the standard of practice. And the first one is one that we've gotten a lot. And it says, is it true that the Code of Ethics now applies to everything that I do? Because that seems overly expansive. And I mean, if you look at the plain language of this new policy statement, it might seem that way. But that's not really what's happening here. So it is true that the new standard of practice 10-5 required NAR to change its policy to expand code enforcement to cover all of a realtor's activities. So that is true, but it is still the case that to be disciplined, a realtor still has to have done something to violate a specified duty in the code of ethics or in one of the standards of practice. And the majority of code of ethics duties are only applicable to the real estate business and to real estate transactions. Standard of practice 10-5 is really an exception to that. Most of the code of ethics still really only applies to real estate transactions. So the code of ethics doesn't really reach into every aspect of a realtor's personal life. It certainly does now prevent a realtor from engaging in hate speech or harassing speech on their personal social media accounts, for example, but it doesn't reach into every aspect of a realtor's personal life. Now, it is certainly true that changing that professional standards policy statement could open the door for NAR to add other items to the code of ethics that do possibly touch on a realtor's personal life more. But right now, it's really just standard of practice 10-5 that covers that. And I don't really see NAR expanding the code of ethics much further than what they've done with standard of practice 10-5 here. The next question, does NAR want to regulate activities outside the real estate business and or the real estate transaction? Or why does NAR want to do that? And so here's kind of NAR's explanation here. The idea is that a realtor's speech and conduct reflect on the realtor organization as well as the entire industry, whether that speech is said publicly on a business social media profile or privately on a personal. So it doesn't matter. It's not like you can just take off your realtor hat when you're posting on your own personal account. People know you're a realtor. You advertise yourself as a realtor. So what you say is still going to reflect on the realtor organization and the realtor brand. And when a realtor pledges to abide by the code of ethics, that means that the highest principles and ethics of realtors have to be followed in all of their activities. And it can't just be abandoned because this is a profession that's dedicated to protecting the best interest of consumers. So put simply, when one realtor engages in discriminatory speech and conduct, those actions demonstrate to consumers that they represent the actions of realtors collectively. Is that fair? No, not necessarily, but that's the way that it seems to consumers. And so that's why NAR does think it's important to police this kind of speech. The realtor brand is built on ethics and integrity, and discriminatory speech depletes the strength of that brand. So that's the idea behind this. That's why we're covering hate speech even outside of real estate transactions in the real estate business. So the next question is, how does standard of practice 10-5 relate to Article 10, which deals with discrimination? So here we've kind of published the entire Article 10. It has two parts. The first part says that realtors shall not deny equal professional services to any person on the basis of these protected classes. And that realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of those classes. The second part is that realtors in their real estate employment practices shall not discriminate against people based on those protected categories. So standard practice 10-5 flows directly from the requirement to not deny equal professional services or be parties to a plan to discriminate. So the first prong of Article 10. Specifically, disparaging a particular protected class may indicate to the public that members of that class are not going to be treated equally by the realtor. Whether or not that's true, it's going to indicate that to the public. That's the idea here. So bias against protected classes revealed through the public posting of hate speech is going to signal that the realtors are not going to take clients maybe from certain protected classes, or if they even do take them, are not going to treat them the same as clients that aren't in those classes. So that's going to lead to violations of the Fair Housing Act due to overt discrimination or disparate impact, and a violation of the the Article 10 duty to provide equal professional service. So next question, this is one that comes up often in the discussion of standard of practice 10-5. And that is, does standard of practice 10-5 interfere with my First Amendment right to free speech? And the answer to that is no, it doesn't, because the First Amendment provides that neither Congress nor any state may abridge the freedom of speech of American citizens. And that's really all that the First Amendment says. It has to do with governmental action. Now, with some exceptions, the First Amendment does not prohibit a private organization from restricting the speech of members, employees, or users. And that's what we're dealing with here. CAR, NAR, and the local association are all private associations, not governmental entities. They're supported by dues for members, they're trade associations, and they're not exercising any governmental function. because they don't have the powers generally available to state agencies, such as, for example, being able to revoke a real estate license. So it would be a different question if, for example, the DRE were to institute a rule similar to what NAR has done here. I don't think that the DRE could do that because of the First Amendment, but we're not a governmental entity. The DRE is. So as such, the First Amendment doesn't preclude NAR, CAR, and your local association from imposing this ethical duty to not engage in hate speech or harassing speech as a condition of membership. So again, First Amendment doesn't apply because CAR, NAR, local association, not acting in a governmental capacity. So the next question is, why did NAR decide to make this change right now? Was this really a major problem that needed to be addressed? And NAR clearly felt that it did need to be addressed now. There are a couple of things that really spurred them to do it. Particularly, there was the social unrest throughout the nation in the late spring and summer of 2020. And during that time, NAR received an unprecedented number of complaints about realtors who were posting discriminatory speech and conduct online, especially on social media. And local and state associations were getting an influx of these complaints as well. And both NAR and the local and state associations were telling people, well, we can't really do anything about that. There's nothing in the code of ethics that prohibits someone from engaging in hate speech. At that time, that was true. So a local association of realtors wrote to NAR President Vince Malta, requesting that NAR consider that the code of ethics should be made to apply to this kind of speech and conduct. Additionally, even earlier than 2020, there was a lot of talk about fair housing, in particular, the 2019 Newsday investigation, which I linked to on these PowerPoint slides. If you haven't read that investigation or taken a look at all the materials and videos from it, you should absolutely do so. It's eye-opening. It's about about discrimination in real estate in Long Island, New York. And it shed a light on discrimination that's been persisting historically, but that many were not really experiencing or were really even necessarily aware of or able to see happen. What they did was they took people they had secret shoppers, essentially, people who had hidden cameras, and some of them were in minority groups and some of them were not. And what it showed was that people who were in these minority racial groups were treated differently than the people who were non-minorities. Very interesting. Take a look at that if you haven't seen it yet. So that was another thing that kind of shed a light that these kinds of fair housing issues were a big deal. The Code of Ethics has embodied principles of fair housing for decades. And as such, NAR's actions to add a hate speech provision to the code is consistent with the spirit and intent of the code, as well as the guidance that's embodied in the Golden Rule. So for all of those reasons, NAR thought now was the time to make this change, and they went ahead and did that. So next question, will I be found in violation of Article 10 if I share or like a social media post that is later found to be discriminatory, even if I personally didn't make the discriminatory comment? And the short answer is, it depends. But here's the longer answer. It's going to ultimately be up to each professional standards hearing panel and is going to depend on the content of the message and the context in which it is liked or shared. Content and context, all of that matters. Now, NAR has said that the target of the new standard of practice is intended to be those who engage in discriminatory speech rather than those who are reacting to it. So, the primary target is the person who actually engaged in the initial hate speech. But nevertheless, keep in mind that you could be found in violation if you make comments that approve of or amplify the discriminatory speech of someone else. So certainly there could be situations where you like and you share something and you even add commentary to it that could be considered to be hate speech, even though you didn't engage in the initial hate speech. Next question, I'm a broker. If my agent makes a statement that is found to be in violation of standard of practice 10-5, will I also be found in violation? Well, this ties into the subject we'll be discussing last, which has to do with the guidelines for disciplining designated realtors and brokers. And I'll be talking about this more, so I'm not going to spend a lot of time on this slide now. But basically the same rules that apply to the disciplining of DRs and brokers for the rest of the Code of Ethics applies to how brokers should be disciplined for discriminatory or hate speech by agents. And we'll talk about this rule and what the guidance says later, but it's also here on the slide. But yeah, I won't get into it now because I've got a whole separate section. Next item, can standard of practice 10-5 be applied retroactively? The answer to that is no. According to NAR, a member can only be found in violation for discriminatory speech that has taken place after the effective date of the new policy. And that date was November 13th, 2020. So any speech made prior to November 13th of last year doesn't fall under this new rule. It's not actionable. However, according to NAR, if discriminatory speech was posted online prior to November 13th of last year, but it remains online after that date, it won't be actionable, but if that speech is reposted or shared after November 13th, then it could be actionable. So, you know, there's a certain social media post, let's say, that it was sitting around, was posted prior to November 13th of last year. But then if a realtor decides to share or like that speech after November 13th of last year, then that could be considered new speech, and that could be action. So next question, the new standard of practice prohibits harassing speech, hate speech, epithets, or slurs. How are those terms defined, and are hearing panels going to interpret the standard of practice consistently? So hopefully the answer is yes. And NAR also at the same time they enacted the new policy, created an appendix to their Code of Ethics and Arbitration Manual, which lays out with great specificity the definitions of the terms that are used within standard of practice 10-5. So I'm not going to go over all of those definitions during this webinar, but I encourage you to take a look at that appendix to see what all of the definitions are for hate speech, harassing speech, epithets, or slurs. Those definitions are the ones that need to be used by hearing panels during cases, and the ones that are going to be applied both on a national and statewide level. So the appendix is designed to make sure that there is a consistent application of standard of practice 10-5, and to make sure that that can be achieved throughout the country. Now, of course, because of the way that professional standards works, it is certainly possible that different hearing panels will apply differently, but NAR has done the best that they can to make sure that there will be a uniform application as much as possible. So another question is, why doesn't the standard of practice cover all of the protected classes in California? And the reason for that is the Code of Ethics is a national policy. And most states don't include all of the same protected classes under California law. There are some states that have other categories that California does not, although I'd say California might have more than most states do. Now, keep in mind that if a protected class is not specifically mentioned in Standard of Practice 10-5, it's not covered by the new policy. But realtors still have to be respectful of all persons and all protected classes under California's fair housing laws. So even if something isn't covered by the Code of Ethics, it still might be covered by the fair housing. But a particular instance of discriminatory speech may not be actionable under the Code of Ethics, but it could be actionable under California's fair housing law. So you still do have to be careful and make sure you know all of the classes under California law, even if it's not something that will be applied under the Code of Ethics. One moment. So this next item is one that's important and one that NAR really wanted to clarify when they just passed some new case interpretations that we're going to be going over after I go over all of the Q&As here. And this question is, the standard practice 10-5 restrict my ability to freely express my political and religious opinions. And NAR clarified that to violate Article 10, as interpreted by standard practice 10-5, a realtor has to say something that is truly offensive and intimidating to a person because of their membership in a protected class. Saying something merely controversial or politically incorrect is not a violation of the Code of Ethics unless it includes harassing speech, hate speech, slurs, or epithets that target a protected class. So political and religious opinions, even if they're controversial, if they're expressed by members in a respectful manner, they are not going to be actionable under the Code of Ethics. So that's how NAR comes down. Next question is, can the competitor just make up a story and file an ethics complaint against me as a form of retaliation? And the answer to that is, well, we have due process when it comes to professional standards. As with any alleged code violation, ethics complaints based on standard of practice 10-5 are processed consistent with CAR's pro standards enforcement process. That gives parties a full and fair opportunity to present their case. They always have the opportunity to have a hearing, defend themselves at the hearing, provide evidence and witnesses, and be represented by counsel. There's also always a burden of proof that has to be met by the complainant. They have to show by clear and convincing evidence that a violation of the code of ethics occurred in order for the respondent in the case to be found in violation. And so all of those protect the respondent from frivolous allegations. This next one is a question that I've had, and NAR still hasn't answered it to my satisfaction, but I'll pose it for you because I think it's a good question. Do realtors have a duty to remove discriminatory statements made by others on electronic media that the realtor controls themselves? So why did I have this question? Well, there's a different standard of practice under Article 15. And remember, Article 15 is the duty in the Code of Ethics that realtors have not to make false or misleading statements about other real estate professionals or their business practices. And this standard of practice says that the obligation to refrain from making those false or misleading statements also includes the duty to publish a clarification about or to remove statements made by others on electronic media that the realtor controls once the realtor knows that the statement is false or misleading. So it occurred to me that the same principles should apply for discriminatory speech that's covered by standard of practice 10-5. So for example, if you have a social media page and in the comments somewhere, someone posts something that is hateful or discriminatory, don't you think that you as a realtor have the obligation to remove that statement that is made on your social media page? I would say that as best practices to do so. NAR hasn't weighed in on the question. For now, we have to assume that standard of practice 15-3 does not apply to Article 10 cases because it only applies to Article 15, unless NAR determines otherwise. But as I said, it's best practices for realtors to remove discriminatory speech posted by others on their social media accounts as soon as they become aware of it. So that is what I recommend that you do, even though NAR hasn't said that you can be held liable under the Code of Ethics for speech made by others on your social media account. All right, so that ends all of our questions. And now I want to talk about the analysis that hearing panels have to apply in all standard of practice 10-5 cases. It's actually a very simple two-part test. So the first question is, did the respondent engage in harassing speech, hate speech, epithets, or slurs? And as I said, if you have a question about how those terms are defined, there's the NAR appendix that goes into a detailed definition of all of those three terms. And then the second part of the test is, was the discriminatory speech based on a protected class? In other words, race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So in order for there to be a violation, the answer to both questions must be yes. So number one, was there hate speech, harassing speech, epithets, or slurs? If the answer to that is yes, then we still don't have a violation until we determine that it is based on a protected class. We have to have both. Must be hate speech, must be based on a protected class. So NAR, at their most recent Professional Standards Committee meeting, created new case interpretations related to standard of practice 10-5. Now, for those of you who are involved in professional standards, you know that case interpretations are official statements of professional standards policy from NAR. They can be used by hearing panels when they're reaching their decision in a case, and they can be used by they can also be used by parties when they're arguing cases before a professional standards hearing panel. So we're going to go over all of these case interpretations. There are 4 new ones that were passed related to standard of practice 10-5. And we'll talk about how NAR applies that 2-part test for each of the case interpretations. One moment, I'm seeing something in chat. Let's see if I can get to the question right away. Do we go by the HUD list of protected classes or by the California list of protected classes? The answer to that is neither. We go by the list of protected classes that are listed under Article 10 of the Code of Ethics. Remember, as I said, there are additional protected classes in California. Those would be applied when we're applying California law. But when we're applying the Code of Ethics, which is a national policy, we have to apply the protected classes that are listed in the Code of Ethics. So let's go through the case interpretations here that are related to Standard of Practice 10.5. Remember, these are now up on the NAR website. As soon as NAR passes a case interpretation, the board of directors votes on it, it goes up on the NAR website, becomes a part of NAR policy. So first one, in social media discussions, Realtor A made the following comments. I think Black people bring out the worst in us. We always knew N-words were violent. They are not Christian. And described Black protesters as animals trying to reclaim their territory. So a consumer took screenshots of the comments, including Realtor A's name, and filed an ethics complaint alleging a violation of Article 10 as interpreted by Standard of Practice 10-5 at the local Association of Realtors. And after a comprehensive review, the association's grievance committee forwarded the complaint for hearing. At the hearing, the panel reviewed the evidence presented by the complainant, including screenshots of the comments. Realtor A confirmed she had in fact posted the statements, but denied that making the statements interfered with her ability to provide equal professional services to anyone because of their race. So the hearing panel entered executive session and considered the intended application of Article 10 as interpreted by Standard Practice 10-5, and they also took a look at the appendix in the manual that defines hate speech, harassing speech, epithets, and slurs. And the panel concluded that the comments Realtor A posted constituted the use of hate speech and slurs. And in their decision, the panel clarified that this public posting of hate speech and disparagement of individuals was based on their race, and that reflected discrimination. So Realtor A's defense was not accepted by the hearing panel, and she was found in violation of Article 10. So here we find the application of that two-part standard. So number one, we have hate speech or slurs, according to the panel. And then number two, it was based on a protected class, which was race. So hate speech based on race, that's a violation of Standard Practice 10-5. It was appropriate for the hearing panel to find a violation. Right, our next case interpretation is 10-7. Realtor A was a registered member of political party Y and routinely engaged in political discussions on social media and in private conversations. Realtor A's conversations and social media posts often included insulting, intimidating, and hostile statements about members of political party Z, including aggressively insulting their intelligence, implying they were unpatriotic, and telling them if they disagreed with him, they should leave the country. Realtor B witnessed numerous instances where Realtor A harassed others on the basis of their membership in political party Z and believed that Realtor A was using harassing speech. He filed an ethics complaint with the local Association of Realtors alleging a violation of Article 10 as interpreted by Standard of Practice 10-5. This complaint was reviewed by the association's grievance committee, who examined the allegations to determine whether, if taken as true, they would constitute a violation of the Code of Ethics. And ultimately, the grievance committee dismissed the complaint since the complainant's sole argument was that Realtor A had discriminated against individuals based on their political affiliation with political party Z. And since political affiliation is not a protected class under Article 10, the allegations in the complaint, even if true, could not constitute a violation of the Code of Ethics. So again, we have the two-part test. Did Realtor A engage in hate speech, harassing speech, epithets, or slurs? It is possible that Realtor A did engage in hate speech here, but that hate speech was not based on a protected class that is listed under Article 10. Political affiliation is not a protected class. So even engaging in hate speech on its own is not a violation of Article 10. It has to be based on one of the protected classes under Article 10. Otherwise, it's not actionable under the Code of Ethics. So that's why the grievance committee made the decision that they did here, which was the correct one. All right, our next case interpretation, 10-8. A group of protesters supporting the equal treatment of women gathered peacefully for a march in Washington, D.C. The group requested and was approved for the appropriate permits, and while local law enforcement was on site to provide assistance, no criminal activity was reported. Realtor A, in response to the march, posted on social media, "These morons have nothing better to do than come all the way to Washington to gripe about a problem that doesn't even exist. This is why women shouldn't be allowed to leave the house. Get back in the kitchen where you belong." Realtor B saw Realtor A's comments and filed a complaint with the local Association of Realtors, alleging that Realtor A's comments against the protesters constituted harassing speech against members of a protected class, and as such were a violation of Article 10, as illustrated by Standard of Practice 10-5. The association's grievance committee forwarded that complaint for a hearing. And at the hearing, Realtor B argued that Realtor A's comments constituted objectively harassing speech against individuals on the basis of sex. In response, Realtor A argued that his comments were directed at protesters which are not a protected class, and that in fact the group was comprised of both men and women. Okay, this is not a good defense. Let's take a look at what Realtor A said again. This is why women shouldn't be allowed to leave the house. Yeah, I'm sorry, this is not going to be a winning argument. In their decision, the panel noted that while Realtor A's comments were addressed to a group of both men and women, they included disparaging, discriminatory comments about women specifically, such that the complainant had demonstrated with clear, strong, and convincing proof that Realtor A had used harassing speech under Standard of Practice 10-5, and thus was in violation of Article 10. So here we have harassing or hate speech against women. The speech is made on the basis of their sex as women. Therefore, it is a violation of Article 10 as interpreted by Standard of Practice 10-5. So again, the two-part test. The realtor is trying to make an argument that, sure, it may have been hateful, but it was against the protesters. Well, sorry, if we really take a look at what you said, it's clearly a discriminatory speech against women specifically. All right, so now we have our last case interpretation that was passed by NAR. This one was the most controversial. There was a little discussion about it. Ultimately, it did pass. But here's what it says. Realtor A was a preacher in his local church and stated before a group of congregants, lesbians and homosexuals are murderers according to the scriptures. One of the congregants filed an ethics complaint against Realtor A, alleging that this statement violated Article 10 as interpreted by Standard of Practice 10-5. The complainant argued in his complaint that Realtor A's statement constituted hate speech. The local association's grievance committee reviewed the complaint and forwarded it for a hearing. At the hearing, the complainant argued that Realtor A's statement constituted hate speech because the remarks were objectively insulting and offensive, and because the speech was based on sexual orientation, a protected class under the Code of Ethics. Realtor A testified that his statements were based on his interpretation of the biblical scripture, and that his teachings were designed to help his congregants understand the true teachings of God. The hearing panel found Realtor A in violation of Article 10 ultimately, noting that the complainant's testimony had provided clear, strong, and convincing proof that Realtor A's statement was intended to insult, offend, or intimidate, and that it was disparaging or abusive, as explained in Appendix 12, that defines hate speech. The complainant's testimony further provided clear, strong, and convincing proof that the alleged speech was based on one of the protected classes under Article 10, which is sexual orientation. So here again, we have someone engaging in hate speech as defined in Appendix 12 to the manual. And then we have hate speech that is based on a protected class, which is sexual orientation. Now, what Realtor A wants here is a religious exception, saying that if I'm saying something that I think is based on my interpretation of a religious text, then it can't be hate speech. And NAR says, well, if you say something that really is offensive to a protected class, saying that is based on your interpretation of a religious text is not going to be a sufficient defense. You can still be found in violation. And of course, that was the controversial part of this case interpretation. There were some people saying that they didn't think it was appropriate for Article 10 to be applied this way, but that was a minority. And the majority of people did vote in favor of this interpretation of Article 10. So that is now official NAR policy. So that's my discussion right now and all of the information I have about Standard of Practice 10-5. I'll be happy to take any more questions at the end. But now I'm going to talk briefly about the new guidance related to disciplining designated realtors and brokers. So a little bit of background on this. So according to Section 3 of the California Code of Ethics and Arbitration Manual, for any violation of a membership duty, including a violation of the NAR Code of Ethics, by a member who is not a designated realtor, the designated realtor may also be found in violation, provided that he or she was the designated realtor for that member at the time the alleged violation occurred. So this is something that's been in the manual for a very long time. It's always been the policy that a designated realtor can be disciplined for the actions of a member under them who is not a designated realtor. In such instance, both may, but are not required to be joined as respondents in any proceeding. The finding of a hearing panel with respect to any violation by the designated realtor and the member employed by or affiliated with them as an independent contractor may be the same or different, and in the event both are found in violation, the sanctions, if any, may be the same or different. So all of that remains true, and Section 3C is also consistent with NAR policy, which provides that DRs have the duty to ensure that their agents comply with the code of ethics, and the DRs can be held responsible when their agents fail to comply. The CAR manual also states that any additional party can be added as a respondent to the complaint. So sometimes the broker of record for a respondent salesperson is added even if they are not the official DR for the agent. So the issue is that many DRs and brokers communicated to CAR that the standards for determining whether the DR or broker should be disciplined have really varied from association to association. And therefore, the section that I just quoted from was applied inconsistently. Some DRs and brokers felt that they were disciplined for actions of agents that the DR or broker didn't know about and couldn't have done anything to prevent, and that wasn't fair. Although it's true that there is a duty to supervise agents, DRs and brokers cannot be omniscient. They can't know everything that their agents are doing. It's simply impossible. Agents are operating on their own much of the time. There's only so much supervision that can really happen. So it seems unfair to discipline DRs and brokers for actions of agents that were contrary to the policies of the DR, broker, or firm and that were done without the DRs or brokers' permission or knowledge. So at the September 2019 CAR meeting, there was a work group formed to create a set of guidelines for disciplining DRs and brokers that could be provided to hearing panels and parties in disciplinary cases. There was some delay in forming the work group. Again, pandemic adjusted our priorities a little bit, but it was ultimately formed and convened in advance of the October 2020 CAR meetings. Here's a list of the people that were in the work group. And the work group met and decided to prepare a set of proposed guidelines for disciplining DRs and brokers. So CAR created guidelines for grievance committees and professional standards hearing panels that are going to be in the format of a printed form. So all of these were the recommendation, and since we've actually moved forward and implemented all of this. The form includes a summary of the broker supervision provisions in the California Code of Regulations and Real Estate Commissioner, and the form provides the following guidance concerning when it is appropriate to discipline DRs and brokers based on the actions of their agents. So here's what the form says. A DR and or broker can be found in violation of the Code of Ethics if their salesperson's violation stems from the DR's and or broker's failure to establish a system to adequately supervise the agents and to monitor salesperson's compliance with the Code of Ethics, or a salesperson's potential violation of the Code of Ethics is brought to the attention of the broker and or DR, but the broker and or DR does not take reasonable steps to remediate the violation. So those are the situations when it would be appropriate to discipline the DR. So second, a DR or broker should not be found in violation of the Code of Ethics. So this is when they should not be found in violation. If the salesperson's actions were contrary to the broker's and or DR's established policies, and the salesperson's actions could not have been prevented by the broker's and or DR's reasonable supervision of the agent. So these are factual questions. That's why we have to, make sure that DRs or brokers are prepared to address these questions during the hearing and that the panels are asking about these things. So the work group thought it was important for the parties in disciplinary cases to be informed of the disciplinary criteria in these proposed DR and broker guidelines. Complainants need to know about the types of evidence they will need to provide if they want to meet the burden of proof to show that a DR or broker has violated the code based on the actions of the salesperson. And in turn, respondent DRs and brokers should know the criteria panels are going to use to find them in violation so that they can prepare a thorough defense to those charges. So as a result, the work group proposed that the DR and broker discipline guidelines are provided to the parties in disciplinary cases anytime a DR or broker is named as a respondent, along with a cover letter explaining that the parties should be prepared to address those issues discussed in the guidelines during the hearing. So that way everyone is prepared, the hearing panel is prepared, the hearing panel is given a copy of those guidelines, so we will be discussing those things during the hearing if in fact the DR or broker is named as a respondent. So a motion was passed by the CAR Board of Directors to implement this policy, and the guidelines along with all of the necessary additional forms and rule updates were included in the 2021 edition of the CAR Code of Ethics and Arbitration Manual, and that was effective as of January of this year. So now, as I said, all grievance committees are using those guidelines when deciding whether it's appropriate to add the DR or broker or not, and all hearing panels are using those guidelines when they're deciding whether or not it's appropriate to discipline the broker based on the actions of the agent. Now, I've had questions about how the grievance committee really knows whether there's adequate supervision, and the answer is not. They don't really know. But remember, when the grievance committee is adding something, that's an allegation. So the grievance committee has to think whether it's possible that the violation resulted due to a failure of supervision. And if it's possible, if it's the kind of violation that could have resulted due to a supervision failure, then those are the situations when it's appropriate for grievance to add the DR or broker. It will be up to the panel to decide whether or not the whether or not the DR or broker did adequately supervise the agent. The grievance committee can't know that during the grievance committee stage. So I think that answers the question that I've had probably the most about this. But now I'm finished with my presentation and happy to open it up about questions about this or any other subject that I presented on, or any other pro standards related subjects. So happy to answer any questions right now.
In the chat box, I have, can the agent go direct to the ethics hotline?
Go direct in, I need a little more clarification here.
I think what they're saying is, you know, if they have a question about an ethics violation, can they go just directly to the ethics hotline and ask a question?
Oh, if they have a question about the code of ethics. Sure, yeah, that's the point of the ethics hotline, that any member can call it if they have a question about the code of ethics. Oh, legal requires broker. Is that true? I thought there's a legal hotline for agents as well.
There is. There's two separate lines.
Yeah, that was my understanding.
One thing that I hear a lot, Brian.
Oh, little echo.
I'm having a weird echo. Let's see.
Yeah.
I don't know. Is it still taking place? One question that I hear a lot is, you know, I think that this is a matter for the DRE. Can you just kind of touch on the difference between code of ethics and DRE complaints?
Well, sure. The code of ethics is a membership duty. It's as soon as someone signs an application and joins the Realtor Association, they're bound by the code of ethics. The DRE doesn't enforce the code of ethics. The DRE enforces real estate laws and regulations. So the purview of the two systems are entirely different. The code of ethics often goes beyond what's required under real estate law regulations, and it includes some things that are actually are not in real estate law or regulations whatsoever. And real estate law and regulations in California include some things that are in the code of ethics. So, you know, one example of that would be the requirement for the DRE number to be on advertising. That's not in the code of ethics. That's a matter of real estate law and regulation. So we're applying two different sets of rules. And so broker supervision is required for real estate law and regulation to make sure members are complying with that. It's also required, as I showed in the CAR manual, to make sure that members are complying with the code of ethics. So brokers have to supervise on both of those aspects.
Hi, Brian. Tiffany Trost.
Hi, Tiffany.
Hi. Thank you for doing this. Can you elaborate just a tad more on what you were saying? If the grievance committee decides that they want to add the broker on, what I hear you saying is if we feel as a grievance committee strongly enough that there weren't protocols in place, then it would be acceptable to add the broker on so that they can then come and show that they do have those things in place.
Right,
Is that what I'm hearing?
Right. Yeah, if it's possible based on the facts alleged in the complaint. I'm getting an echo again. Can we fix that? Okay. No. Okay. No. All right, better now? Okay, good. I'm not hearing the echo. Great. So I think, what was I saying? So the grievance committee, all of the grievance committee can go on is what's alleged in the complaint. So this is a factual issue. If based on the facts alleged in the complaint, it seems likely or possible that the violation resulted due to a failure of broker supervision, that's when it's appropriate to add the broker/DR to the complaint. And remember, when you're on the grievance committee, you don't know whether there actually was a failure of supervision, because that's the role of the professional standards committee once a hearing has taken place. So you're only adding when it seems possible or likely that the violation resulted due to a failure of supervision.
Wonderful. Thank you.
Sure. I'm seeing the questions in chat. Let me read through a couple of them. Question, have there been many reported violations regarding the use of how no longer allowed descriptive term of master bedroom versus primary or main bedroom in advertising? I've seen the continued use of it often in the MLS and on social media. So my understanding is that this was like a best practices that was suggested to comply with fair housing law. I've never seen this come up in the context of the code of ethics. I don't think you could argue that it's hate speech or harassing speech to use the term master bedroom, or that it means that you're not providing equal professional services on the basis of race due to the connotations of the use of the word master bedroom. I haven't seen any cases where this has come up in a code of ethics context, but I have heard about the issue and I know that people are aware of it. I haven't seen any cases where this has been an issue. All right, our next question, do you anticipate expansion of code of ethics or guidelines based on the ever increasing use of the social media medium? I mean, I think this new hate speech standard of practice was based on social media. I'm not sure if it ever would have come about without that. Even though it's not just directly addressed to social media, it applies to statements made in any context or any medium. I certainly think that there are other things where social media applies. I don't know if this code of ethics needs to be expanded to address social media specifically. One example, of course, is Article 15, where there's the duty not to make false or misleading statements about other real estate professionals or their business practices. Now, of course, that also applies to social media. You can't make those statements on social media as well. But I'm not sure if we need additional aspects to the code of ethics that are just applicable to social media, since many of the duties also apply to social media. If you can think of anything that just applies to social media and you think needs to be in the code of ethics, let me know, because that's something that I could potentially suggest to NAR. But I do feel like most of the social media issues are already covered by the already existing rules in the code. All right, our next question is, what will satisfy the broker requirement of proper supervision? And so that's why on the D15 form, we kind of refer to the guidelines from the state that talks about what is proper broker supervision. So you can kind of rely on those. I don't necessarily have them memorized, but they are, I believe, quoted on the D15 form that the hearing panels and the grievance committee are provided. So that's kind of like a general idea of what would constitute proper broker supervision of agents. Yes, Tiffany.
Okay, one more for you. On the speaking about other real estate agents on social media or anything else, what we recently had, and I was really questioning whether we made the right decision or not, was the real estate agent never specifically named the other agent that she was talking about, but the agent that filed the complaint was stating that it would be easy enough to dissect if somebody looked in the MLS that they had done a transaction recently. Therefore, that's who she was speaking about. But she never actually spoke about the agent's name. So it almost is like we can't even discuss our situations with other real estate agents because they might be able to dissect through our sales in the MLS who we were talking about. So I was just curious if you could shed a little light on
Sure.
that.
Sure.
Well,
Yeah.
first of all, remember that to be in violation of Article 15, it has to be something that is false or misleading. So it's not that you can't say something, negative about another realtor. It just can't be false or misleading. That is an important distinction to make. The other question is, could it be a violation if the name of the specific real estate agent isn't mentioned, but it's clear based on context who is being discussed? That's a hard case, but I think you can make the argument that it is appropriate to find a violation here if it's, patently obvious that you're talking about one particular individual when you're making the statement. So yeah, I think that's hard. I've never seen an NAR case interpretation addressing that specific question, but I do think you could find a violation in that circumstance. Right, we've got a question. Shouldn't each broker have all of their agents sign an addendum to their independent contractor agreement with all of these new code of conduct rules? What would be in the addendum? Just, I'm not sure how that would really protect the broker, because there's a duty of the broker, regardless of what would be in a contract, to supervise the agent. So, yeah, I'm open to ideas there, but I'm not sure how an addendum really solves this issue. All right, I see a hand raised. Karen?
Hi, I have a question. When there's multiple articles in a grievance complaint, and there's, whether it be multiple respondents or maybe you're adding the DR to the complaint because of potential failure to supervise, how do you handle it if you feel like some of the articles apply to some of the respondents and some might apply to the others?
Fill out a separate G2 report for each respondent. That's the easiest way. It just helps to clarify, who is being alleged and accused with what. So yeah, there's no requirement that there has to be only one G2 form for all the respondents. You can fill out a separate one for each person. Yeah,
Gotcha.
I think that would be the way to go.
Thank you.
Sure. All right. Do we have anyone else? Jenny, I'm not seeing anyone.
I think we have one more. What happens if a broker is not responding to calls and emails regarding one of his agents and code of ethics violations?
So I think that would be, by what happens, do you mean, would that be a failure of supervision? I would say yes. And then also might be helpful to contact the ombudsman, because sometimes the ombudsman can help to open up those channels of communication. So certainly that could be a situation where you'd want to use the ombudsman. But I think the other question, if the broker just never responds to any inquiries related to the actions of an agent, then that would be a failure of supervision, because I think that falls under one of the items here, which is, let me go back to the definition. Yeah, a salesperson's potential violation of the code is brought to the attention of the broker and or DR, but the broker and or DR doesn't take reasonable steps to remediate the violation. So, if they're never responding, it's being brought to their attention, but they're not doing anything about it. So that could lead them to be in violation as well. All right, there's a couple of new things in chat, I think. Let's see. Curious, do you know if people are submitting violations for 10-5 that don't rise to a violation? In other words, does it seem people are being too aggressive in reporting potential issues? I don't think we're seeing that. We've been asking at the CAR meetings in regional reports, we're asking each region if they're getting a lot of 10-5 cases, and most are not getting that. So I don't think we're seeing any instances of over-reporting here. I know that was a concern initially, but it's not bearing out in the data.
Okay, I think our questions have slowed down. Last chance, anyone? I think that's it, Brian. Thank you so much for joining us and sharing all of this good info. And I'll be sure to send out the PowerPoint that you send over to everyone.
Yep, I'll email that to you right now, Jenny. Yeah, thanks everyone for attending and for asking some great questions. I always like to help out all the volunteers. That's my role at CAR. So thank you so much for inviting me, Jenny.
Thank you. I know I keep you very busy with all of my questions. I appreciate it.
that's what I'm here for. So.
All right. Thank you. Bye.
All right. Take care, everyone. Bye.